Selling late, selling late.
Go ahead and take your seats, please. Good morning, good morning. You want to give me about 15 minutes? How's everybody?
Good.
Good to see everybody's smiling face this morning. Anybody got a house deal they just did? Tell me, quick, 60 seconds. No?
People want too much.
People do want too much. That's why you have to learn how to negotiate. And you gotta market and market and market. You can't market to one person and expect to find a deal, right? You gotta market to the masses and, somewhere in there, there's a needle in the haystack for you to help them out. That's what we're looking for, right? People that need help. Okay. So the deal that I ended up finishing up on was a probate deal that was a referral to me. Is that a good deal?
Yes.
Do you think referrals are a little easier than starting from scratch, cold calling, marketing?
A whole lot easier.
Yep. So typically less money in marketing, right? You probably don't have marketing expense on a referral. But my experience has been if somebody has referred me, the fact that that person has referred me carries a lot of weight with that seller. In this particular case, it was a probate deal. And they actually accepted a lower price than what I offered in my counteroffer. So Lenny knows what I'm talking about. So this was a probate deal. They originally wanted, I think, 265 or something, and which was a discounted price. ARV is in the 365, 380. Now that it's done, we did measurements. We have an additional. We thought it was 1748 square foot. It's 2049. So we got a bump in our after return value. But we went into the deal thinking 265-ish, and I ended up buying it for 240. But we were at like 215 to start, and they didn't like that, so they come back and they wanted 250 or something like that, and I came back at 245, I think it was. I don't remember now, but anyhow, I wanted them to do the roof. I wanted them to initiate the roof claim, and I would pay them a couple $1,000 if they would do that, because their insurance paying it's going to be cheaper than me having to pay for it. And they come back and said, "No, we'll take 240. We don't want to mess with insurance." And I can only think that they already filed a claim, got money, maybe, or that, or they just didn't want to deal with it. I'm not sure why, but anyhow, so I got it at 240, and the rehab is. Contractor tried to tell me it was done on Friday. It's not. A lot of loose ends. Going to be a punch list. He knew there was going to be a punch list, but they didn't finish the thing. Missing doorknobs and
Wow.
electrical was still in work, still trying to finish up electrical stuff. But I hope to have that done. It was a complete rehab. We're actually pretty close on budget. I don't have final numbers yet, but probably one of the closest. I don't know if that's luck or finally getting my experience fine tuned a little bit to be a little closer on what the costs are going to be, but it's coming together. That'll be a nice one. Well, yeah, wasn't a lot of uh-ohs, surprises.
Did you say you added square footage to it, or just it's got more square footage?
Well, it was not on public records. Public records was 1748. They had enclosed a back porch, and I figured that was probably not on public records. So,
So you have to hold permits back forth from the reflected on public records or it's called county and town name, things will get state.
we don't even do that. It's measured. There's one of the people in the listing agent's office does the assessment and then put it on drawing and then that's submitted to MLS. I don't know how that actually gets to the county. Anybody know? Weston, do you know how to? If you, well, thank you. Welcome.
I'm sorry.
Since you worked at the city for a long time, do you know if I have a house, public record says 1748 square footage, but when I sell it, there was an enclosed porch on it that bumped it up to 2,000 square feet. How does that new square footage ever get to the county records? Do you know?
So if they do a permit,
If-
you know, if and added it that way, then the county, the Tarrant Appraisal District would find out and then report it. But if it's done, if they just did it in their backyard as a project and didn't tell nobody, it won't be on there.
Does that ever catch up? I mean, unless somebody goes down there and physically reports it, does it ever get caught up by the county?
It was one that in Dallas that they didn't know that the garage, the detached garage was gone for over 15 years. It was demolished and they didn't even know. So unless somebody's protesting taxes and be like, oh, y'all charging me for, 17, I don't think nobody say, oh, you charging me 1,700 square feet and, but it's 2,000. Yeah, nobody's gonna say that, but the other way around, it probably get reported.
Right.
I would say if there's an appraisal, there's gonna be financing involved, and there's an appraisal, or they'll come out and measure the house, and it could be separate, because they'll come out and appraisal will say, well, your house is 2,000 square feet now instead of 1,700 square feet, something had to change. When the town is built, town is appraised.
But the appraisal
17
not
years
gonna
later.
make it to the appraisal district, it has to get to the county to show on something. So
Okay,
it's permits, it goes to permits or somebody saying something.
all right, well, I just curious, but anyhow, I hope to have that house finished by the middle of next week. And we'll start getting cleaned up and staged. It'll probably go on the market, based on my conversation yesterday, probably a week from today. There'll be hopefully, no, we're not doing pictures. We have rain problem this next week for pictures, so it's probably gonna be 2 weeks from today that it'll be an open house on. So, hey, Ryan. Okay. We'll go ahead and get started. Welcome everybody to the West DFW REI group. I call it the watering hole for North Texas investors. Come in, drink the Kool-Aid, learn all about real estate with us, right? Couple admin notes to get started here. Thank you to all of our vendors and volunteers that help us. We couldn't do this by ourselves. And we really appreciate your help. Please put your phones on mute. If you do need to step out, feel free to do that. Restrooms are around past the checkout there at the front door, back in that corner. All of our deal and vendor stuff is in the back table here. So please go look at all that stuff and take some of that stuff. And that's what it's there for. Okay. The manager is kind enough to give you all 10% off on your bill, so make sure that you see that on your receipt today. On your bill. And please take good care of the waitresses. I have some free investor stuff. At the end of the day, if you're still here, I have some things that I'm trying to give away that I don't need. I'm moving and sold my office yesterday. Martin's office closed that for me. Thank you. And downsizing, building a home office, and I will not move all this education material. So please help me come visit we're gonna talk about that, but come visit and we'll show you all the stuff I have. Thousands of dollars worth of stuff. Please take a moment, check in with Facebook, tell people about the group, where you're at, what you're doing. And, you know, these events, we need your help with sharing these when it goes out on social media. Please share it with your network to help grow the group. Isn't it beneficial to everyone in here? We have more people, right? The relationships, the deals. Are we all here to do deals? Make money? So the more people we have, the more opportunities, right? So the investor education material I was mentioning, this is just some examples, but you know, you can come Monday through Friday. My pointer don't work on that screen. It doesn't like it, but Monday through Friday, 10:30 to 2:30 to call or text first. I actually don't text right now. We have a texting, Vonage business has a text problem. You know, everybody knows about all the SMS issues going on, right? With spam and junk, and it's a big problem with all the networks. And there's a lot of stuff going on right now, and Vonage is trying to stay on top of it. Vonage is the business phone system I use. And we are unable to text right now because they're trying to keep up with all the regulations and stuff.
On election year.
Say again?
It's called election year.
Yeah, I don't know about that, but anyhow, I have a ton of stuff. We've sold some stuff, but all of it's got to go. And there's our address in Weatherford, and there's our office phone number. And if you don't have this, you can always go to the website and click the contact us button on the group website. Okay. Our mission is to provide the best real estate investor education and support and community in North Texas. So that's what we think of ourselves as a community of real estate investors. And we want to help you. We want all of us to help each other. Okay. I think that's important, and it's always been important to me. And, you know, we've been doing this for 15 years this month, actually. That's hard to believe, isn't it? I used to have hair. Yeah, Lexington remembers.
Yeah, 2014, I think I was a member since then.
We
Jeans are a
started.
little bit bigger back then too.
What's
The
that?
jeans are a little bit bigger back then.
Yeah. No, that's true. I've lost a lot of weight. We won't go into that, but. Okay, so vendors, partners. Earlier I mentioned our trusted partners, and the trusted partners is growing. This is where we're at today. These are all people you can trust when you need help. I would encourage you to go to the Trusted Vendors tab on the website, and you know, all the contact info. Listen to the short little videos to hear a little bit about them, but then all the contact information is there. We have a couple of them here today, so we're just going to go around the room real quick and have them stand up and introduce themselves, and then you'll get to see them put a name and a face together. We're going to start with Miss Robin. Pressure's on.
Stand up, I'm not much longer.
That's
So I buy and sell real estate notes, and they're secured by real estate, obviously, typically single family homes. I do dabble in a little bit of commercial, but it's gonna be kind of small stuff. All across the country. So if you moved here or have family in another state, we have a lot of notes in other states. And they can be performing notes, somebody's paying, it could be non-performing, they're not paying, they haven't been paying in 2 or 3 years, they're still living there, or it's vacant. Semi-performing, you know, they're making payments every 60 days, whenever they want, any of those, we look at all. I don't claim to be an attorney or know anything like that, and I don't want to. People like Martin can handle that stuff. Get a lot of good advice from the attorneys regarding notes. And, but if you do have some questions, you're creating a note and you're going to want to cash out, because you're not going to want to hold it. And, you know, you want a lump sum money. You don't want $900 a month in payments. You want your $50,000, $60,000, $70,000, $80,000 back that you put into it. Then call us and we'll talk about it. And let me tell you what pointers of what you need to do, because I see a lot of notes written that people, I mean, they have an attorney draw it up, but they leave a lot of things out, and that just makes the discount better for us. Anyway, just feel free, all my stuff's on the website, my father back here, just give me a call and we'll talk about it.
Thank you, Rob.
Thank you.
Robin has been with us for many, many years, and she's happy to help you. I would encourage you to sit out and go, take her out to lunch, buy her coffee, find out how she can help you, and maybe you have something to do with her as well. So she's happy to help you. It's better to look at that stuff ahead of time and do it right up front. Like she said, a lot of people that say they can do it, but don't really know how to do it right. So sit down and have a conversation. Mr. Lenny, you're up next.
Hey, good morning, everybody.
Lenny's another one that's been with us for a very long time.
It is.
Really?
Happy Halloween, everybody. Hope everybody had a happy Halloween and a safe one. I tell you, over the Halloween, I was hanging out with this ghost. Been hanging out with him for a while. And he finally, after it was over, said, "Where are you gonna go?" He said, "I guess I'm gonna go hang out at Malibu." I said, "Well, what are you gonna do down there?" He said, "I'm gonna take my girlfriend. You know, she's got a real ghoulish figure." And he said, "But I got this kind of condition. I'm gonna have to go see a doctor and get an approval." And I seen him a week later. I said, "Where are you gonna go on that trip?" He said, "Well, I went down to the doctor." He said he can't see me right now. So he didn't get to go. But anyway.
So there's your added bonus.
You just thought I'd throw that story in there real quick. But I've been in business for a little over 45 years. Roofing is really important to your houses. If you go look at a house, you're gonna buy a house, sell a house, thinking about buying a house, thinking about selling a house, call me, let me go look at it. That's gonna be one of your biggest expenses. It's gonna be anywhere from 9 to 15 grand. And that's a lot of money to miss on when you're buying a house or selling a house. You get in there and say, "Oh, I'm gonna have to spend an extra $15,000. That's gonna do a lot to your budget." Well, that's like with Tim's house. We went in there and looked, and Tim knew I'm gonna have to have a new roof, so we're gonna have to bring that price down to, $12,000. So I need a $12,000. You get it, pay it, and we worked it out where he got the house less money than what he wanted for it, because we knew it needed a new roof on it. And that's what everybody does. 50%, just a statistic, of all houses you buy are gonna have a new roof on it. That's just a statistic. Just because we're in dire needs and people just let roofs go, and you're gonna have some kind of roof work done on it. Something, if it's not replaced. So always get the roof checked. Roof and the foundation. And we're probably the two that is the main thing. Everything else is kind of cosmetic. If you can get the roof and the foundation fixed, everything else is lipstick. But call me. I work with insurance companies, and sometimes I can go back. Even if you buy the house, I can go back to the previous owner and find out their insurance company and get them to pay for it, because if that house was insured and the homeowner willing to go back to their insurance company and they can get it paid for, because they're liable if I can find an insurance event that happened while they own that house, they still got to pay for it if it's within 2 years. That had that happen. So not always.
We've done 2 insurance roofs in the last 2 to 3 years.
Right. That's on people that were selling houses. So don't give up. Just give me a call. My phone number is 817-718-3127, or look up my website at roofmax.pro. Roofmax.pro. It'll tell about me, my son-in-law, my nephew-in-law. My son's come to work for me. He was in the hair salon business. They sold the hair salon, and they both work for me now. One's in marketing, the other one's in operations that I've got. My nephew-in-law's is learning sales. So give us a call. Thanks a lot.
Thank you, sir. Appreciate it. Thank you for being here today. Lenny's done a lot of roofs for me over the years. Just did my personal house a few months ago. He's getting ready to do my new home office. my backyard here, hopefully in the next 2 weeks at least.
Yeah.
And, that house looks really good when I'm getting ready to sell. Look, that new roof just makes the house look so much better. So, thank you, sir. Okay, Mr. Ryan, good morning, welcome.
Morning.
Is this Ryan Junior we have with you?
It is. We got Rory here playing.
Is he our future vendor?
I don't know. So I work for Longhorn Investments. I think I know everybody already in this room for the most part, but we are a hard money lender. We finance up to 100% of your costs. That's 100% of the purchase and rehab, as long as it doesn't exceed 75% of the ARV. If your deal is higher than 75% of the ARV, you're probably buying too high, because in DFW, so far this year, I've written about 180 loans just here in DFW. And of those 180 loans, the average is 73, just shy of 73%. So if you want to be on average, you should be buying right around 73%. That's your purchase price, plus your rehab divided by the ARV. That's how we get to that percentage. October 1st, I wasn't here for the first meeting in October. We just bought a new company. So if you'd heard, they weren't too big up here, but Skybeam out of Atlanta, we bought them and now integrated their staff, but more importantly, we integrated their financing funding capital. So we now have over $600 million. We are a direct lender. We don't sell your note. You get a note from us, you will be dealing with us the entire time. A lot of hard money lenders are brokers, so they may tell you this is what your draw process is going to look like, but depending who they broker it out to, that's going to change. So we at least will be consistent with you all the way through the project. And the big thing too is when we took over another company, we got all their staff and they were overstaffed, which is great because we were a little understaffed. So we're back to closing in 5 business days, and we'd love to at least give you a quote for your next deal. I did bring a bunch of sample term sheets so you can see what a $250,000 loan with us would look like. If you're paying all of the title fees, that means yours and the sellers, so the owner title policy, all the escrow fees, you should expect to pay about $13,000 cash to close for a $250,000 loan. But that's all I got.
Thank you, sir. Appreciate it. Congratulations on all those loans.
Thank you.
Have you, out of curiosity, have you gone back to, you're tracking the borrowing percentage. Have you gone back to see what the forecasted ARV was versus actual sale price?
I haven't looked to see what our appraisal value versus the actual sale price is. I can tell you our appraisals do come back a little bit high. And that's because our appraisers are going to assume the highest quality of work for the budget and scope of work that you gave them. The other thing to think about though, and this is why I think the appraisals maybe aren't always necessarily high, but they're higher than what you should be selling for. Because if you're an investor and you're paying hard money rates, is hard money cheap? No, it's not. It's really cheap to get into it because it's less money out of pocket, but overall the rates are higher. They're about 12 to 13%. And so you want to get in and out of that because you don't want to keep making that payment. So you should be pricing 5, maybe even probably about 5% below what the market value is to get that sold.
So the reason I ask the question is that I find that almost every house that I rehab, because of the quality of the rehab that we do, I'm always selling over what I initially estimated for the ARV. So I'm just curious,
I can tell you our ARVs have been coming back higher than what people are telling us. Like I had somebody just yesterday, he assumed 390 as his ARV, came back at 419. And so sometimes, so maybe 390 is the actual price, and our appraisers are just being a little aggressive, but I don't know, that's a good thing to maybe think about going and tracking.
just curious,
That just means I have to go back and try and search when people, because
Right.
about a third of our loans are people are keeping them as rentals.
Yeah, well, that's a little harder.
So that one I wouldn't be able to do, but yeah.
I have not been tracking it. I just know in my mind, I'm selling for more than what I initially estimated.
So something to think about is data. Like we were talking about, data is king in this industry. The more data you can get, the more research you can do, the larger sample number you can get, the better. So if you guys ever want to know any of the data that I have, I'm more than willing to share it. I do split it out because I write loans in all 10 of the states that we do lend in, but I specifically separate out my DFW loans. This is where I'm based.
Have you noticed the increase in days on market for DFW?
I have not looked at that directly, but I know just the trending numbers that we get out of the real estate institute or whatever it is down in Texas A&M that they have gone,
So,
especially year over year.
so they have gone up. That's reflected in our MLS data in your dashboard office. Do you have any, without putting you on the spot, do you have any comment on our days on market going up?
So,
Everyone, this is my new assistant, Maria. Who
that's good.
Also a licensed agent, right?
Yes. So, as you know, a couple months ago, we were probably about 2 to 2.5 months market, inventory. So recently I was reading 2 nights ago, we're close to now 3.5. So definitely. And also, even though the interest rates did go down, as we know, in September with the Feds, but now between the last 3 weeks, they have gone up. So as of yesterday, our average now, I had a client over 800 credit score and her interest rate is 6.8. So definitely that point that we had, I think I lowered. Back up.
Yeah, and I read an article yesterday, or saw the headline that September's used home sales went down and new construction starts went down in the month of September. So, but all that's good news for us, right? As investors, higher days on market, people need to move. We might have the solution.
In the winter months, it normally slow down anyway.
That's right.
Holiday time.
Yep. Back when it was a crazy market and you couldn't stop a sale, even the winter months kept being hot, and selling fast. But with the market being a little slower now, the winter months may not be so good for us.
We're looking about 45, 60 days.
Yep.
I've seen.
So that's what worries me about this house. I told the contractor you need to be done by 1 November. He said he was done, he's not. So now that worries me because we're moving closer.
And Tim, you can probably speak to this, but I've seen been in real estate for a couple election cycles now. Elections always too. The month leading up to election, things get a little bit tighter. But right after, people kind of calm down and start to breathe a little bit more. No matter who wins.
Right.
That's kind of how it always
And you
goes.
have the NAR settlement, lawsuit going on
Yeah.
too, that should be finalizing. The final hearing is this month. So some people.
Okay, moving on here. So, thank you, Ryan. Appreciate you, supporting the group. We have a new vendor with us today, Milton Colgrove. You want to introduce yourself, Milton? So Milton just joined. He has not, we have not sent the announcement, but that'll be coming out here next day or two. Glad to have you on board, Milton.
Thank you. Appreciate it. Well, I'm the Colgrove of Meyer and Colgrove. We are a small two-person law firm. Mr. Meyer is a litigator. He handles evictions. Most of his clientele are property management companies in the state of Texas. So he is the guy who does evictions. I'm the transactional nerd in the office, which means I don't go to court. The only time they let me out of the office is if I'm picking lunch up for the both of us. I tease the difference between a transactional attorney like myself and my partner, the litigators. I walk by a mirror and I keep walking. He walks by a mirror and looks at it and goes, "That's not bad looking." So there's a difference between the attitudes between the two, but I handle, been in business longer than I wanted to admit. I handle asset protection and entity formation, real estate transactions. Obviously I wouldn't be here. Single family homes as well as multifamily. Have done, did about $200 million in sales and transactions in multifamily industry last year. And help in all aspects of your transaction from a residential standpoint. You have questions. Tim and I spoke. My attitude has always been I would rather have an investor call me and ask questions before you get yourself in trouble. But my goal is for you to never meet my partner I never want you to really need a litigator. That usually means you're in trouble in some way, either because you're the landlord, need to get someone else, or because someone's upset with you. So feel free to call. All the information. We brought some brochures, some cards, some other things. So again, I'm here to help you as a new investor or as an experienced investor in your legal needs, and happy to help in that. Grateful to be a part of the team.
Thank you, sir. Welcome aboard. So Martin Garcia with Select Titles here today. He's speaking to us, so we'll introduce him here in just a minute. Let me cover the rest of the vendors we have. August REI is a third-party servicing company. They've been with us a long time, so if you're doing any kind of owner finance notes, they'll service those notes for you. They'll collect payments, make payments, do the end of the year tax statements, send the notice of default, and report to credit. Very important service for you if you're in the owner finance business. Service First Mortgage with Ruth Ann Dunham, who is normally here. She had a conflict with something else. But she does all kinds of different conventional financing loans. She's our longest running vendor that we have, and she's happy to sit down and talk to you about what kind of funding programs she can help you with. Her and Ryan talk quite a bit about who can do what to try and help. That's her bottom line is, how can we help, you? They want to help you. So, which I love. That's why they're here. We want them to do that. SVN Trinity Advisors is another new vendor they're a commercial real estate brokerage. So they are the ones that actually sold my office in Weatherford for me. And Andrew had a conflict with being here today. Texas Bank Mortgage is right across the street here. They are the ones that provide our nice, beautiful big room. They are going to support us for the Christmas party next month. So please tell everybody we got them to let us back in. Ryan, 30-second update on Ryan. Did he tell you much?
Randy.
I'm sorry.
You're good.
Randy.
He said he's doing better, much better, and that's why he was able to do that. He's planning on being there with us.
He can let us in. He can't do anything. We said, all you gotta do is turn the key to let us in the door, and that's it. So his back problems are not much better. I'm not sure we'll know more next month about whether he's having surgery or not, but unfortunately, nobody else in the bank will commit to being there every Saturday to let us in there, but it's a great space, and you'll see that next month if you've not been there. Propelio is our preferred software choice for comps. If you are not an agent, don't have MLS access, Propelio is the tool to use for that access.
That's what we use.
Yep. And there's a lot of brokerages using it now as well, but it's very simple. That's the nice thing. And the most important part is it's MLS data. So very, very key point. Okay. There's a lot of tools that claim to have comps, but don't let them fool you with that word comp until you hear them tell you that it's MLS comp. Okay. So very important piece. And then Bryant Company Property Management. Andrew was not able to be here today, but they are our property management company of choice. They're managing some of our properties for us. And they're out in Weatherford, but they do Weatherford in Parker County and Tarrant County. Okay. And I don't think I missed anybody, did I? Okay, moving on. All right. Partners you can trust. So we just talked about vendors. Now our affiliate partners are all the tools type of things. Okay. So I won't go into that now, but go into the store. You can scan the QR code, go right to it, or you can go on the home page and click on the store, and you'll see all these different tools. A lot of these we've got some discounts in there for you, but go check them out. These are tools that we are either have been using or are implementing into our own business. So vendors, we're looking for more. We want you to be able to come here to find the type of support you need. Whether it's a rehab contractor or HVAC contractor, electrician, make-ready services, if you're out there working with these folks and you're happy with their services and you think it'd be a good fit for this group, then let's get them in here and talk to them and see if they're interested in joining us, okay? I'm always asking for this stuff. We need more. Not everybody's gonna qualify. So, you know, we want, the best of the best to come in here and support you. So, take 10. This is designed for you to go, now that you've seen the vendor's name and face, you're welcome to go meet them, give them exchange cards. But do that quickly. We'll get back in our seats and we'll proceed.
I won't be able to stick around, but I will be here for the whole meeting in December. I'm gonna really try and promote it and push it out. So if you get some marketing material or like like something I can post on, yeah, please send it over to me and then I will get it pushed out. Ideally, I would say by the middle of the month if I can.
Well, we're already, it's already on the calendar.
Yeah.
So we'll be.
I think I know he's talking.
We already have it on the calendar. I'm planning to get something done, so I'll tell my VA.
Thank you.
Okay, folks, take a seat. Let's go, rock and roll. We're running late. Turn 2.
I was a second baseman before a lawyer, so I know how to turn too. That's what y'all said.
Okay. Since we are running late, I'm gonna skip ahead and we can get right to Mark. 1 second here to switch slides. Okay. Any questions so far? It's okay if you ask questions.
Oh, well.
Oh, well.
Yeah, I like that one better, actually. Oh, well.
Oh, well.
I know they have, a couple people expressed wholesale interest, him. Do we know what the next coming month or in the classes of wholesale topics?
I don't really yet, but we will be doing that. Give me. Okay. We'll make sure all this technology's on. Okay, so most of you know Martin, but Martin Garcia was simplified title.
Nope.
I select title, sorry. And a few changes. But Martin's been with us a long time. He's closed a lot of deals, just closed my office yesterday. He's done a lot of stuff with me over the years and with many of you. He has had this, done this presentation for similar several times, different topics, but done this kind of presentation, legal presentation updates and stuff that have all been very, very good and informative. What you're going to hear about today, is this important or what?
Oh, yeah.
Okay.
Absolutely.
And I'm probably guilty of not paying enough attention to all the dean stuff. But then again, who do I call?
Ghostbusters.
No, Halloween's over. I call you a freaking lawyer.
So, Martin's very knowledgeable of this stuff. We're glad to have him here as one of our trusted vendors. So sit back, listen, take notes, and I'm gonna turn it over to him.
We gotta take a picture first. I was at Fred's. You guys know where Fred's is? Where the old, where did I start teaching with you? Buffalo West.
Buffalo West.
That's where I think I met you. That's been 10 or 11 years now. So when I was at Fred's having a burger, I was like looking in the back room and I was like, first time I taught him, and I took a picture, so we're gonna repeat today.
You remember?
I don't remember which topic it was, but
I don't have a clue, but it was good, I'm sure.
yeah, that was
I just started
early
laughing.
25. Yeah,
Cool.
thanks. Yeah,
Thank you.
that was what
It took about 3 or 4.
Okay, thank you. They're good, I'm sure. I gotta get as skinny as Tim one day. So yeah,
This isn't by choice, by the way.
um,
I don't want you to take my avenue of doing it.
understood. 10-4. So yeah, it's been a great ride getting to teach these topics. Don't quite recall if I've done this one with this group, but obviously you guys have heard me speak quite a bit. Thanks. I think that one might have been big surveyorship. You guys have heard me talk about that, divorce. We see that before, right? For probate. Deeds. Why is it so important at the end of the day? Well, that's exactly what you're buying. Title to the property. And how do you know that you have 100% or whatever interest? Because now people are buying fractional interest in property. I'm not sure that's a topic for another day. But 100% of what you intended to buy, right? Not just trusting me because I draw up the legal docs and I close it to my title company. Know what I'm doing, but there's also differences and complexities in every single transaction, right? Celebrated that anniversary teaching for this class, and actually today, Facebook reminded me that got licensed to practice 12 years ago today. So November 2/12, but I've been in title since May of 06. So there'll be 19 years title next year, practicing for 12. So pretty exciting day for some of my colleagues. Yeah. For those that didn't know that part. I'm going to control the slides here. Is that it, Tim? Okay. Well, let me go back up one more time. You're like, it's First National, Martin. You guys know my law firm's, my initials, MAG, Mag Law. We close, I'm a fee attorney. What's a fee attorney? You guys know what that is?
You get paid to.
I know, I'm gonna get paid regardless.
Right.
So, Tim mentioned it earlier. Spend a couple minutes if you haven't. Watching the vendor videos. I had a really good time with Tim updating my title flag and explaining what I do when I do right now. So the easiest way to explain it is it's a franchise, right? I don't own Select. My buddy Brad does. And I've known him for most of the 20 years I've been in title. So most of you know a couple agencies that I have owned, Texas Secure, Simplified, etc. So this one is me not being with any partners. I think I have a grasp of doing this on my own by now, right? That's what I'm doing. So I don't have to own or run a title company, but in exchange for a fee of your title premium, I pay Select, so they do all the back end and processing of the actual title policy, but we work the file as if nothing changes in your world. You wouldn't know that. I'm just explaining what the flags are, right? And that's why I paused on First National. What's that? Well, every transaction is not just backed by my office and my title company, MAG and Select. I need an underwriter. I have a pretty damn good record of no claims on the closings that I have. Texas is still probably about 2 or 3%. So 2 or 3 out of every 100 transactions might go into a title claim, but we have to have an underwriter backing it too. And that's who actually wrote this course. And most of my underwriters who do write courses allow me, because they trust me, to go and teach them on their behalf. So that's who First National is. And just a little bit more about the title industry. If you didn't know, a company like that's going to show up on your title commitment, right? Whenever my staff sends you the commitment, it's going to say that company or something else, not Select, not bad. That's who's going to back your policy. Every transaction, whether I have to involve the underwriter or not, they get 15% of the premium. Everyone. And that's what goes into their bucket to then defend title claims. There is one. And as we're navigating this presentation, I'll stop and talk about potential claims issues on the deeds that we talk about and other scenarios. All right. make a little sense, more history on what a fee attorney is, I'm a franchise for a title company, and then who the underwriter is and how they come into play.
Hey, Mark.
Yeah.
On a purchase and sale agreement where you specify the title company.
Yeah.
Would it be Select Title or
That's
would it, was that?
That's it.
Okay, so it's not that big national
No, no,
guy, okay,
you're not gonna deal with the underwriters.
okay.
Well, in most cases can't, right? Because you're mostly gonna be asking legal questions. That's for me. So yeah, good question, right? Because sometimes, and it's okay, it's the same shop. Sometimes people put mag law. I just have to change it from one bank account to the other. But yeah, if you're closing a title transaction with me, it's Select Title. And got about 10 cards back there if you don't already have one. Same spot. I've been there for 5+ years now when I went on my own. So yeah, over on West 6th. All right. We talk about a lot of legalese whenever I'm up here, and things make sense to me, not just in my presenting, but I've been practicing for a while too. Stop me. I want it to make sense for you. I want you to get something out of me, right? So stop me, ask questions like you're already used to. So that's why I start with, the heck does that mean? Irreducible complexity, right? A single system which is composed of several interacting parts that contribute to the basic function, and where the removal of any one of those parts causes a system to effectively stop functioning. I know what the spirit of the elements of a deed are, the essential elements. Who's the grantor? Who's the grantee? Yeah. So we're going to have words of grant. We'll get deeper into that. We're going to have a legal description. We need signatures, obviously, to effectuate the deed. Delivery is an important component. We'll get into the weeds there on what constitutes delivery versus not. And an acknowledgement. It's a question mark there because an acknowledgement is essential in some respects, but not necessary. If I write on this napkin right here and grant one of my properties that I own to Tim, but it's not notarized because nobody's a notary in here. I am sure there are people here, but that's an effective deed. It's not ineffective because it's not notarized. It's just, it affects the title world and the recording of that instrument. It can be effective all day, but he can't go and record it and memorialize it and say, Martin sold me this property. Well, I did, but 99% the county's not going to accept it and won't record it if it's not acknowledged by a notary. And that's why there's that question mark there. Grantor must have capacity, be an adult. Can you sell a property if you're under 18? Doesn't happen often. It's mostly in the probate context, right? We're dealing with an estate and title, and like more times than not, folks don't understand who's going to have the capacity because there is no will potentially. There hasn't been a probate. And when I've got heirs that are under 18, that's when I have to every time involve the courts. Otherwise, I can involve folks who are 18 and over. Sometimes I've had scenarios where I sit on the file for a year or two because it's not that hairy, it's not that sticky, and most people are in agreement, but we're just waiting for the minors who are going to inherit to turn 18. It's happened several times. Not subject to a court order limiting capacity. What do you think that means?
Take a seller who has dementia. And
Yeah. I'm thinking still more legally, but yeah, let's run with that. Okay, how many of us have closed with the power of attorney? We'll start using my acronyms, POA, right? We close with POAs constantly. And if it's durable, it says this instrument, for those that might not know, this quick recap. I'm going out of country. I need to sell my office. Tim, can you be my agent via this power of attorney so we can close on it yesterday while I'm out of the country, right? I'm the principal, he's the agent. So when we deal with durable POAs, the language says this isn't affected by my subsequent incapacity. So only if we had a durable POA can we potentially still do that. If not, then yeah, there's no capacity. But let's stick with court order. So where I was technically going there is, we've had these conversations a lot. Divorce. When there's no way that the people divorcing are going to agree on how to settle on the properties, who's appointed to do that for them? Close.
Trustee,
Close. A receiver. Okay? A receiver is court appointed to handle the transaction. And that receiver is gonna go get a real estate agent, right? That's well versed in that area to then pretty much handle every part. Tim or anybody in this room, Martin, cannot go under contract with him or her while they're divorcing, right? Because you're either married or you're not. That's the truth. So no one, you get, oh, I got a deal this weekend, cool. Yeah, I just signed one of the parties. Well, what did I just say? They're married or they're not. And especially if it's their homestead, that's a invalid contract when you only have one party. You gotta deal with both. So that's one of the court orders. If they're not gonna agree, the splitting parties, a receiver will be appointed, and guess what? You don't have control over selling your home anymore. You gotta run everything through the court. The other one that I see all the time is, any guesses?
Letter of testamentary.
Close, that's probate. That's a different order, especially on the uncontested. What I'm thinking of is bankruptcy. A lot of people in your world, in the investing world, and that's why you come to title companies like us, right? That I have access to search bankruptcy records too, because it happens. And especially when y'all are buying the pre-foreclosures, well, yeah, maybe they might have talked to me at some point or other attorneys, but then they waited and, oh, it's foreclosing Tuesday the 5th. That's in 3 days. They're going to file bankruptcy Tuesday morning before the sales start, right? So if that happens to you, whether you have a contract with someone or not, once that BK is filed, it's not their property to sell anymore. You said trustee earlier. That's who has the authority to approve a contract that you're submitting or else. Yeah. People have submitted, hey, I found a BK. This bankruptcy is against your party. This contract's no good. You're gonna have to go run it through the trustee and the bankruptcy court. Yeah.
so is that where you'd go to you to get them stay listed on the bankruptcy so they can?
Good question. Bankruptcy offers a stay, right? Offers debtor protection for a minimum of 2 weeks while they get their shit together, if you will. You got to follow the rules on the debtor side too, because the creditors have, and owners and sellers have rights as well. But he asked if I'm the guy to call for a stay lifted, right? That stay is that 2 week protection I talked about. No. Good question. I don't practice in federal court. I practice in any other court in the state of Texas, but not federal jurisdiction, just state jurisdiction. Bankruptcy is a special part of the law. It's all federal. I have a colleague that I refer. She and I go back and forth. She's out of Grapevine. If you know Lauren Powell, that's who I send my parties that are facing a bankruptcy. My landlord is facing a bankruptcy, whoever. She gets to stay lifted. As soon as that protection's done, comes right back to me and I finish it up. We've done foreclosures like that. We've done finished evictions like that. Yeah, I'm not going to do it. I'm not licensed there, and I really don't want to mess with bankruptcy. That's a different code. I love the property code, the family code, and the estates code. That's about it. Got to stay in your lane sometimes. Grantor must exist. I know that you guys have seen this. Hell, it happened to one of my Tims, if you will, that I've been closing for about 6-7 years. Lots of closings. Well, guess what? What's happened to me too? I'll throw myself under the bus. If you allow your entity in Texas to lose good standing, guess what? Title's going to say you can't close right now. We're delayed until then. The most common one when it happened to me before I got a firm taking care of all my entities and dues and whatnot is the franchise tax. You don't pay your franchise tax, your good standing's eliminated temporarily until you make good with the comptroller. Okay, that happened to one of my really good investors. It does happen, right? Watch out. It's not just the franchise tax issues, but if you have entities or multiple, like a lot of us in this room do, go and check out every status at the comptroller level. Because if it's not in good standing, you can't close a deal with that entity with me until it's fixed. So that's defunct. Same thing with corporations, LLCs. We can't do it. When someone's in a pinch and has to close on that property, we can't wait for the Texas Secretary of State to finish up the paperwork, and Secretary of State and Comptroller kind of work hand in hand there, then what I do, I get creative and put special language in this defunct corporation or limited liability company, and then have you sign in your individual capacity too, right? If I can prove that you and you and you were the only ones involved with this defunct corporation, then we'll create a line item for a defunct corp and then all the individuals. That way I'm covered and you as a purchaser too.
Now, I seen that happen before at the city. It was
Yeah.
a partnership that went bad and
That's
they
it.
didn't.
Yeah, recall those. The grantee must not be married to grantor. Generally speaking, and this one we can get in the weeds too, that's more of a marriage and divorce class. Deeds between spouses during marriage do not change property from being commuted. Yeah, that's a general rule. Okay, you can change it through other avenues, but just FYI, because that is a common misconception there. That's straight from your family. Oh, you like that? Grantee must actually exist, kind of like we talked about the selling entity. If it's defunct, I can give you this slide too, so you can take your pictures, or Tim can, or Maria.
Yeah, this presentation will be available.
It's gonna be on the.
Must actually exist, kind of like we said. Hey, our due diligence is making sure that that seller exists and has the capacity to sell you that property. Well, I can't insure, because I insure the purchasers and the lenders, the Ryans, the Ruthans, and the purchasers. Well, if you're buying an entity, it's got to have the same or rules that I apply to the sellers. It must exist, it must be in good standing, etc. Watch out for death people. That's why I always use this term. Plain title. I'm going to ask for all the docs. If I can't find them, which I can find most of them in the Secretary of State, but there are cited docs that I will need just to prove who all the players are. Oh, shoot, there's a dead person that would have had to sign if I didn't find out that they weren't here, right? Words of grant. What I always say too when we do the contracts class, read everything. If you're using the track 1 to 4 or whatever contract you're using, do yourself a favor and read the entire thing. If you don't understand the clause, then why should you be signing? Number 1. Number 2 is call your lawyer so they can tell you what you're signing, what you're getting yourself into. And I say that because most deeds that we're going to go over use those words of grant. Grant, sell, convey. There are a couple covenants. Those are super legalese that we can get into later after you read the PDFs on your own time, and then you have questions. That's more for the property 101 class, first year law school. I can't go right now. All right, mentioned legal description is one of the elements. Must be sufficient to locate and identify property without the need of additional oral testimony. And for our purposes as a title company, it's going to have to match everyone on the commitment, on the survey, et cetera, et cetera. Common issues I see here, using simple legals that you'd find on the appraisal district website, right? Most of the time, that's not the complete legal description. And that's going to potentially mess up a chain of title and the deeds of record. And most of the time, that's when people do deeds on their own and don't involve themselves. They're not that expensive, guys. I'll do that. Right. I think Tim would probably say that too, doing it for 20 plus years. So just at least get someone legalized involved.
So on this one, it's best to use the physical address than what the county has a legal description.
That's even worse. The physical address is not even close to being a legal description. That's a physical tag so you can locate it on your GPS. It's not illegal though. So that's probably the least form. And then what the county has in tax records, but then what's actually a proper deed records that matches a survey, that matches what title finds, that's your true legal description. And it gets hairy, especially when you're not dealing with platted subdivisions, right? Block. You're dealing with acreage or meets and bounds and calls that sufficiently locate and identify property because it's not platted, right? You got to start here at this rod and you got to go this way, this many feet, turn these degrees, right? Remember your right of ways and all those?
And then
City
plat
page.
reference, you have to have a plat reference and a
It's platted.
slide and all that.
And if it's not platted and it's one of those meets and bounds calls like I just did, then you're gonna go back and not find a plat, but I'm gonna reference this deed from 1908. With respect to this deed from 1908, and then this piece, because we're adding some to it, yeah, it can get complicated.
So do you have to go and locate all the iron pins and all that?
Not me, the surveyor. I'll send someone to do it. I hardly ever site check, probably 1 or 2% of the time. If I really need to, then I will, but surveyor will go find all those pins. Hey, Martin, I'm having a hard time finding this pin, or I think this call's off. They were off X number of degrees, or they were off X number of feet. Right? And that's when we start getting the hairy part or the technical part of the title commitment and title policy. Remember that word shortages in area, right? It's in the check contract, part of the policy. That's where it starts coming into play on what's covered and what's not.
Is that where you'd write an exception then to the policy?
Bingo.
So I presume that if we give you a Trek contract, that we've put the legal description from the county records on, you're going and getting the real legal description.
That's it. Yeah. You're gonna give me the basic information and I'm gonna go find the actual completely. Yeah.
Well, no, I was gonna make a comment. I think what's really important is, because I did a lot of commercial stuff in our trailers. You don't, if you find out later down the road that because you didn't have the correct legal description, you want to sell and you find out that the pin is not where they said it was. I mean, you may have a garage that's on your property. You may have fence lines, everybody just assumes because they look at the property that, oh, well, this is where the boundaries are, they've got trees planted or whatever. That's not the case. Wait till the surveyor gets out and he says, well, you've got your garage is 5 feet on your neighbor's property. It's been for 20 years, 15 or 5 or whatever.
That one just like that.
It happens more than.
Yep, they call me.
And that can be a real mess dealing with a neighbor who probably says, well, I've had that property for ever. So
You start asking how long has it been like this, right? So whatever
you
state
get
you're
it
on.
back.
Yeah.
Yeah.
It's just gonna get nasty. And then I start asking, did you get a policy? Because if not, you're gonna spend a ton of money on lawyers that can't defend and indemnify your boundary issue right there, which relates back to the deed, right? Which Sam and everybody else is gonna read the deed, and we're gonna get to this, but I'll go ahead and tell you now, because I get calls like this all the time too. Wait, I don't have to sign a deed to accept the property? No. Buyers hardly ever sign deeds. You didn't already know that. So if you're buying and you want, my point here was read your deeds, whether you're selling or buying. Yeah, most, if not every time, when you're dealing with me, I'm going to draw them up, or my firm is. But if you're buying and when you go to closing, you don't sign a deed most of the time. Ask for it. You have every right to ask for it, so you can read it before the seller executes and make sure that you are protected. Do it. Promise you, save yourself some trouble. Signatures, all grantors must sign the same as appears on the deed. Things change. Sometimes people change their names. Sometimes people use initials and not. That's when we start using the now known as, formerly known as, right? For what the deed records show, county shows to what their name is now. Easy fix on our end. So delivery, a deed's not effective, like I said earlier, until it's delivered. Recording is not necessary to pass title. I think I mentioned that too. But recording constitutes delivery, even if it did not pass through the grantee's possession. What does that mean? Tim just bought a house from my title company, didn't ask to see it. I didn't offer it to him. Seller signed, we sent it for recording. Why is that delivered if it never touched his hands or he never put eyes on it?
Public record?
Yeah, it's called constructive notice. Because it's public record, all of you are considered to be on notice that Tim bought a house today. Or Tim's entity, right?
So back to the buyer signing the deed, when it was a mineral reservation or mineral reservation, I think sometimes they make the buyer sign
Including
it.
mine. Why did I do that? It's not a requirement. It's a cover your ass mechanism.
So they'll know that they're not getting the minerals. right?
Especially when minerals were a make or break deal here in North Texas. Yeah, if you're gonna reserve minerals, because I didn't have to do it, but I was one of those title companies doing it. I had people in the back end saying, I didn't get the minerals and try to rescind the transaction. Yeah, so that's why if we were having, right now, it doesn't really freaking matter, but.
Yeah.
You know, I'd have
Thank
buyers sign, and you understand that these potentially lucrative minerals are not conveying with the surface, because what do I insure? Surface. I don't do anything with the mineral estate. That's all for landmen and oil and gas folks.
Yeah, I didn't know about the buyer having not being the sign, but what's to keep a bad actor from having a Superfund site and him granting somebody the liability, which is far higher than what the property is worth? What's to keep them from doing that to somebody?
Bad actors, right? And we're gonna get into type of deeds here in a second. So that's why people use quitclaims. You guys have heard of quitclaims, and it's not quick, guys. It's QUIT, quitclaim deed. All right. Because that one doesn't have any pretty much guarantees or warranties. So what's to stop them? They better not use a general or special warranty deed that we're going to cover, because then there's liability and their ass is going to be sued and lose bad in court, if not go to jail for fraud. Right. But if a bad actor is doing that, all right, I don't own the dirt that Denny sits on, but Tim trusts me, and we talked after class. Hey, I'm actually the owner here. I'm actually looking to sell it. Yeah, I quit claim it to him. Yeah, I'm a bad actor, but does he have much recourse against me? Good luck.
That's like a Kirkland Bridge.
There you go. I think that was in one of the law books too. Delivery can be through a third party. Who's that third party most of the time? And that's why it was delivery, that it didn't pass through Tim's hands. I's not on it. I'm the third party because when you contracted and put my title company on it, I'm basically assigned as the facilitator of the transaction and the fiduciary in that respect to, I don't have a fiduciary duty, but to make sure that that recording happens. So that's delivery on his behalf when he bought the house, because I was the title company that took care of it. Okay, back to the notary public that we talked about. Technically, a deed's still effective if not acknowledged. It merely can't be filed. Those of you that go down to the courthouse, right? You know, there are two. Go down to the basement here in Tarrant County. They're two different sides. One of them's the official public records. Good luck trying to pass anything through that. And then across the hall, you probably get something through the courthouse that's not acknowledged. But again, you're gonna run into issues, whether it's just a simple deed recording without acknowledgement, a foreclosure notice, what have you. Get it acknowledged most time than not. Notary, yeah.
Okay, so this makes me think, when you're referring to acknowledgement, because I don't want
Notary.
to see that one. You're the notary. So I've had discussions with the notary at the bank. This has been years ago, and it was not for a deed, it was for something else. But, and it was a big document. It was like 60 pages or something, and she had to notarize my signature 15 times. So she said she had to read through the whole thing to understand it before she notarized it. My understanding is you're notarizing my signature, not the document. So can you clarify when you're talking about a notary notarizing, acknowledging, is it the document or the signature?
It's the signature is the short answer. You know, I never have short answers. So I take it that she has either been through or knew of someone that had gone through litigation where the notaries are brought in. I always look to the notary. If it's a fraud deed, hairy deed, sticky deed. And why am I saying that? Because, oh, you're agreeing to acknowledge the signature, but you better freaking know what you're acknowledging. Because you are an officer of the court. That's what that seal's for. And you have to uphold what, even though it's so easy in this state to become a notary, you are an officer of the court. And if you're acknowledging something freely just because and don't know what you're actually acknowledging, I wouldn't do it either. That's what I see there. But yeah, you're essentially acknowledging the signature, and that's why you get identification to not just see if signature matches, those change too. But hey, we can get in fraud all day, right? Is this actually Tim? Is Tim's twin, someone that looks like Tim, or he's impersonating someone that looks like him. Right? So that's what I see there. That's the acknowledgement section of the code, civil practice and remedies code. All right. Kind of started there a second ago, but these are the 4 general types of deeds, right? Or general terms, maybe use another word. 4 most common types of deeds: general, special, a deed without warranty. I never use those. Why would I ever, as a risk taker, title insurance company, or a quitclaim? Guess what? I sometimes insure quitclaims, depending on the situation, right? Analysis, what's the scenario, who's signing the quitclaim, or who's signing the quitclaim that's in the chain of title, and how long has it been there, right? Timing's always in play.
Are those two the same, the non-warranty, deed without warranty and quitclaim?
No. Deed without warranty, good luck getting any recourse. And good luck for me trying to defend your title. Probably don't ever insure that.
Why would somebody want to not?
Cause he would
You wouldn't
do
want to, but
the,
but there's some people who only want to. One time in almost 19 years, like I said, have I had to insure after a lot of analysis and careful consideration with underwriters like First National, a deed without warranty, like kind of like you're going Hillwood, commercial context, but when you're stepping into someone's shoes, the one I'm referring to was a lengthy, nasty, drawn-out probate for about 3, 4, 5 years, multi-million-dollar estate, and the trustee that was appointed by the court, probably a receiver too, on top of the trustee, to represent the trust and the estate. I'm not signing anything but a deed without warranty. I am just court appointed. I'm not guaranteeing, warranting anything. You don't want that? We're not closing. That was the only time I've ever dealt with or insured a deed without warranty.
it's
But-
understandable though.
Yeah. No, if I was in their position, sure, I'm not gonna warrant anything. I said it was a multi-million-dollar estate tied up in litigation for, God, this thing was closer to 10 years. That's how much there was in play. So, yeah, I wouldn't want to sign that either. Because then you're right back in litigation too. Someone's gonna get mad. Oh, there's that much left in there. I mean, lawyer up and go take you right back. So, yeah, not the same. I definitely use quitclaims because even the last session made it easier for me to rely on quitclaim deeds that have been recorded for a long time. A little bit harder whenever, oh, it was just recorded last year. But then that goes back to analysis. How big of a risk am I willing to take?
Yeah, I'm not seeing the contract for deed, which has a lot of
That's
legal
not a
errors
deed.
with it.
We're talking about deeds today. That's not a deed. Okay. That is a contract that says, I am selling you this property, but after you fulfill these terms, then I will sign one of these. That's what that is. We're not discussing that today. Talk about that one for an hour too. All right, most widely used. What does your track 1 to 4 have promulgated in there? Read your contract if you didn't already know that. The general warranty deed is right there. Why do you think the Texas Real Estate Commission on the track 1 to 4 promulgates general? It's interesting. Yeah. And is that what you said? Yeah. I mean, lawyers, real estate pros galore meet in that committee to change the contract right now for like every 2-3 years, it seems like. But yeah, they wanted the most protection there, generally speaking, because that the spirit of the track 1 to 4 is for not people like us. It's for retail agents as well that sell homes to people that are going to go occupy, right? So that's why that's in there, one of the many reasons. So what is the difference between, or what does a general offer besides the greatest protection? I bought a house in, call that 2000. I sold it this year in 2024. The general warranty, if I sign that as a seller, I'm not just guaranteeing, warranting the proper term, title from 2020 to 2024. I am warranting title
To the dirt.
to the sovereignty, to the dirt. 3 owners ago, I don't know who they are. I don't know what they did. I don't know who they owed. I don't know if they got sued and had judgments, but I'm warranting that. Every time I teach this class, people are like, well, why would I sign that as a seller? That's scary. Why? Why would you? Because it happens every day, whether people know it or not. And the contract, if you don't change it, it's telling you to sign it general. Why would you sign it as a seller? Isn't that kind of scary?
Get insurance.
That's why you get title insurance. That's why you get a title.
Title policy.
Because I'm doing that research for you, Mr. and Mrs. Seller.
Yeah, you don't.
That's it. And you're not my new insured, but if I mess any of that part up, not just a title claim on the buyer, but the sellers can come back and say, oh, hey, you didn't get all the sellers. You didn't get all the people with capacity. I owned this property long before whatever I said, the year 2000 or 2020. And I never got paid on this valid lien that affected the property. That happens. And if you sign a general, then guess what? You can be brought into that litigation for that judgment or lien holder prior to 2020. But you're protected because of that title policy. You had a comment?
Yeah, I thought they only insured up to 25 years or certain amount of years. I don't think, do every policy go back to their sovereignty? They don't, right?
It depends on what title plant we use and how far backdated that is. Mine generally go back to 1979. That's already over 40 years. Good luck trying to bring a suit, right? If it's
It's
a lot,
45 years because that's the year I was born.
there you go. There you go. I wouldn't bring that up for that reason, but yeah, my plans generally go back to 79.
So say there was a mechanics lien by, say, a roofer hypothetically.
Yeah.
That the seller didn't disclose to you. And you go, I bring you a contract. And you don't notice the mechanics lien. That's where the title policy would protect me from that mechanics lien.
If the mechanics lien is valid, yeah. Yep, that's right. And if title did not find it, albeit not disclosed, file a claim, and we have to go and make it right, indemnify you, make your title right. And then we'll go sue the seller and anybody else involved that didn't disclose, despite the hypothetical that I didn't find it. There's a bad actor that didn't disclose, right? So, because you sign documents as a seller that say, there aren't any more liens that aren't on this settlement statement. And it's notarized, so that's how I can go back and sue the seller if something like that happens. Special. Let's not even talk about who owned it prior to me in 2020 buying it. Special, and that's why most, the commercial promulgated contracts doesn't have warranty or general, it has special, right? And builders in the residential context want to use special. Trustees, like I said, executors of an estate. Special is only, hey, the time that I or who I'm representing owned it. I'm not warranting anything prior to that. Protect yourself a little bit more as a seller. We title companies are a little bit more inclined to research more and not want to insure these because they're not general, but we do it often enough, especially with builders, especially with commercial deals. Questions there on special?
Well, maybe a couple big things, but, so we have, let's say we bought a note and we had to foreclose. And then, so obviously we get the deed and, then we end up selling it. We'll use a special warranty deed, because we're not homeowners, obviously.
Mhm.
We have no idea what this before that. We were doing special warranty deed.
What was the last part about?
Well,
Comment?
do you see any reason why that would be an issue? Because as a lender, you're not gonna know anything,
Well, yeah, I get it. I'd use a lesser form because you're selling it. Your buyer might, if they're well
What would you
versed,
use? What else?
see without warranty. Because then you're not warranting anything.
No, I'm not warranting anything.
You are if you're signing a special warranty.
We use special warranty.
That's what I'm saying. You're warranting.
But what is the other deed? What would you use?
I just said deed without a warranty
Oh, deed without a warranty, I'm sorry.
or a quitclaim.
Yeah.
But where I was also going with that is if your buyer's well versed, they're gonna get their attorney involved and say, no, we're not accepting anything less than special. And that's why you probably got in front
Yeah,
of
we've had
execution.
a couple of times, and it's just like,
Yeah,
we've all, we've only owned it for 6 months,
right,
so not waiting.
right.
So only a
If I was the one that bought she sold it to me on special warranty. Could that be upgraded some kind of way to general, or is there a reason for it, or?
No, without
Selling it could be special also?
Doesn't have to be. When you sell it, whatever the negotiations of the sale is, and whatever you want to offer up, right? If the other party, I'm not telling you to pull a fast one, but yeah. If I can offer a deed without warranty because I'm very uncertain about these last 6 months, I don't want anything that can pipe me. So I'm gonna offer a deed without warranty. Oh, they're well versed or they're lawyered up, they're gonna ask for a minimum special warranty. So it doesn't automatically have to keep being the same type of deed, it can change.
And if I had that special warranty and I get a title policy on it, whether I sell it, like I sell it, so the title policy is.
Yeah, not just because of the title policy protection, but what contract did you sign? Did you sign the track on the form? Well, that obligates you as a seller to sign a general.
So, I had a question. So with trustee deeds, only an attorney can convey those, and constable deeds, only those, legal type entity, like, it's their position that conveys the title, right, that can use those type conveyance?
Yes, to the position on the constable deed, you're probably used to that from your time with the city, but the trustees deeds, I'm the trustee on all the loan docs that I draw up, but it doesn't have to be an attorney.
So is she a trustee if she's the note holder?
Yeah,
I have been.
yeah. You can be too.
So that's not but so it's not conveying warranty, right?
That is not a fiduciary. All you are is a placeholder. All right. I sell a house to you. You borrow money from a bank that appoints Tim as the trustee. Doesn't have anything to do with that property. But if the borrower defaults and the bank says, trustee, do your thing. Go and initiate foreclosure proceedings. That's all it is.
So a trustee's deed is conveying just whatever the trustee.
That's mostly in the foreclosure context. It made it to the courthouse steps, it's sold, then whoever the trustee, whether it's an attorney or not, will be a trustee's deed conveyed to the new buyer.
Okay, but what they're conveying is unknown, like.
Well, we're gonna cover trustees deeds if we get there today.
I'm stop asking.
That's all right. They're good questions. So my trustees deed, and it can get complicated because it's not really releasing any lien that was foreclosed. That's an issue. And yeah, it's not really warranting anything. Why would you? You're the trustee, you're a placeholder.
So it's a deed without liens.
Most of the time, mine are. Yeah, if I foreclose as a trustee, why am I gonna put myself into any potential liability? I'm just doing a job, right? On behalf of the lender, that's not getting paid. We talked about special. Remember, when the claim is by through or under grantor, but not otherwise, only the time that the grantor/seller has owned the property. Problem with special warranty deed, I briefly mentioned it in the title world, because the deed does not warrant title prior to the current owner. It cuts off claims against prior grantor. So now, not just you resting easy because you got a title policy, but look for what kind of deed. Not just reading it, but it cuts off claims, right? If you, on your policy, accepted a special warranty deed, denied too, then good luck for you being in debt. Well, I'm still gonna have to indemnify you most likely, but then I'm in hot water because if something prior to the current seller owning it comes up, then I have to go clean it up. That can be very, very timely, costly, etc. Deed without warranty, sometimes called bargain deed, sell deed. This deed uses the words grant, sell, and convey and gives those two implied covenants, but does not contain any other warranty. The quitclaim is the deed that also has no magic words, grant, sell, convey, and no warranty. So I mentioned that I do insure these sometimes. Why? I know like people have heard that name change to one of them, but a lot of times people change their name after divorce. Yeah. If I can prove that the parties to the quitclaim had capacity and had the title to convey, it's pretty easy in divorce context, sometimes easy in death context. But if they're strangers that were quitclaiming, I've seen this all around Fort Worth the past 20, 25 years in deed records. Like I said earlier about selling Tim the dirt where Denny sits. Two strangers to each other quitclaimed last year, filed it, and then it gets to my office, but you just found a killer deal. I'm not gonna, most likely not gonna insure with those facts because of strangers in title quitclaiming. Why'd you quitclaim? And then it's only been recorded for a year, right? Most of the time, I won't touch a quitclaim unless it's a divorce or easy provable context. For 5 years that it's been recorded of record, I won't touch it. And I'm pretty flexible, creative, do things the right way, but read the code. 5.
Changed it.
And I call these QCDs, quitclaim deeds, generally not accepted. That's general rule. Told you what we can do to accept it. And they generally do not vest title in the grantee because it's just, I'm quitclaiming you whatever I own of this dirt, if any. I might not even own any. And you're accepting that risk. Shame on you if you do. Yeah, no claims from the buyer in that context against the seller. And coverage can be void, and that's on the policy. You can use a quitclaim to divest, not to vest, right? I can get rid of my interest in property, but it doesn't technically give it to the one that I'm giving it up. That scenario that we kind of talked about, husband and wife divorce, wife is awarded the property, nothing filed in the official public records, the OPR. We can use a quitclaim deed to divest the spouse's interest, and the divorce decree is the operative document that actually vested title in the awarded spouse, okay? So when that happens, I know some of you have heard me say this, I have 3 of my best friends are family lawyers in town. I always tell them, you guys know how to mess up a chain of title by the time it comes to me. Because they tell people what to do on a divorce decree. How many times is that really going to happen? Not often. Obligating people to refi within a certain amount of time. Telling people to sign a special warranty deed, sign a quitclaim deed. It just doesn't happen a lot of times. It's back end work that gets missed too often. So I have to go and clean it up by the time it actually gets to being sold at a title company. Not just clean up, corrections too. So telling you all that because in the OPR and the official public records, if I have a copy of a decree that tells me husband or wife is fully divested of all their rights, title, and interest to this property, I can take that decree, record it in the official public records, and that's a conveyance. If what was ordered in the decree did not actually happen, I can get it, record it, and now it's a conveyance. That can save us a lot of time, heartache from having to go find this ex-spouse that doesn't want anything to do with this anymore. Hey, I need a signature from you. Stick it in your ear, right? So that's another way to convey interest, finding that decree, making sure it has the magic language and recording it, right? I redact personal information, especially when, well, look, I knew that someone was probably thinking it, especially when there's kids, right? When there's kids involved in divorce for the interest, for the benefit of the kids, a lot of times the lawyers will use initials. If there's anything about the kids, it's blacked out. No way, no how, but everything else with respect to the property, I will leave on there and record it in public record.
So the same thing with a transfer on death deed. So do you need to, file the death certificate or you need to get a title company and make? How do you solidify this transfer on death? I know it transfers right after the death.
Yeah. So stop there.
Yeah.
Legally speaking, that's it. Title has now vested in the beneficiary of the transfer on death deed.
So it's
You want it to,
already.
yeah.
Right,
Transfer on
okay,
death
yeah,
deeds are
it's
filed right
already
away.
filed, but once they pass, how do you let them know that, hey, this
Who's
person,
that?
the public?
Well, death certificate's automatically filed with the county.
So those are very hard to come by unless you're
In
next
deed
of kin now.
records, it's not
So,
filed.
so where I'm getting at is, it's an automatic conveyance. You don't have to technically do anything. When you come to title company, and we see, oh, you're the owner of this property pursuant to a transfer on death deed, yeah, I'm gonna say, let me see a death certificate. That's all I need. You don't have to, that's what I'm saying, guys. The county and the appraisal district is not title. It's not title to property. It's just a informational database. So if you want the county and appraisal district to show your name, yeah, you go and kind of do the same thing. Hey, there's a transfer on death deed here, here's death cert. Oh, okay, we'll change it. I hate when the appraisal district changes who's on title because it's messed up a lot, just like those damn family attorneys do. You're laughing, but I guarantee you, I'm a lawyer and I get those calls daily. All right, what's a deed of trust?
That's mortgage.
It is. It's this state's version of the mortgage. It's a form of a deed while we're talking about it, but I still see it to this day, confusion as to what the actual deed is versus what a deed of trust is. Just remember that if it says deed of trust, it's this state's version of the mortgage. It is the lender's security in getting paid back. Brian's not going to issue a loan, Rutina's not going to issue a loan if you don't sign a DOT, a deed of trust, right? So kind of like we were talking about earlier in different contexts, when I do loan docs, whether it's owner finance, private loan, hard money loan, whatever, I'm usually the trustee when I do my own docs at my firm. If my lender stops getting paid, I'm the placeholder. All I do is, all right, you need me to enforce this deed of trust and start foreclosing? It's the security for the lender. Yeah.
One of the things to note on the deeds of trust, though, is whether or not there's a power of sale clause or not.
Yep.
Which will determine whether it's a judicial or non-judicial foreclosure.
Judicial meaning that we can go and sell it at the courthouse steps without filing suit and without having to involve anybody else. Okay. Judicially, you have to file suit and go through the process, right? And back to recording importance, if a deed of trust is not recorded, you're going to have to get judicial. You can't go to the courthouse steps if it wasn't recorded because not everyone's on public notice, constructive notice. So you would have to foreclose on what's called a vendor's lien, which is in a warranty deed. All right, substitute trustees deeds. Kind of like what we were talking about trustees deeds earlier. If the trustee no longer wants to be that placeholder, or there's a conflict of interest, or you as a lender just want to appoint somebody else, lawyer or not, that's whenever there's a notice of appointment of substitute trustee and then a substitute trustees deed. Everything else is pretty much the same as a trustees deed. Real quick, we got to keep going.
Okay, aren't those the ones that are normally awarded in the winning bidder at the courthouse?
Whether it's trustees or substitute, the only difference is it's a new trustee, right? I drew up loan docs almost 20 years ago. That person probably couldn't find me anymore. It's like, hey, I need to substitute somebody else out. You can be my trustee now. That's a little different, but yeah, whoever's awarded the property highest bid at the courthouse steps, that's you either get a trustees deed or that substitute trustees deed. Yeah. All right, in the probate context, if you've been appointed executor of the estate, then don't sign any of the warranties, any of the deeds that we talked about earlier. It's got similar language, but different and more protections for you as the representative of the estate. You're going to want to sign an executor's deed. We talked about sheriff's deed, right? Executed by the county sheriff, that capacity that Lexington was talking about earlier, right? Pursuant to a writ of execution or at a foreclosure sale. And then deed in lieu of foreclosure. All right, we're pretty damn close to the foreclosure sale, which is Tuesday the 5th. And they didn't file debtor didn't file BK, debtor didn't do anything else, but said, hey, I just want out of this. Well, that's one of the better outcomes for the lender who's foreclosing. We'll do a deed in lieu of foreclosure. Talked about vendor's lien earlier. Anybody know the spirit of what that vendor's lien is? You can read that, but I know it's kind of small font. You'll read it later on your own. So I buy a house, I get a loan from the bank. The loan doesn't pay the entire sales price. So how is that protected in essence? Really not until you sign a deed of trust too, right? So the warranty deed that the seller signs, conveying title to the buyer, says that the buyer paid cash, and then however much the buyer borrowed to complete that sales price. And in exchange for that protection, a vendor's lien is issued to the seller. But then the seller, in essence, doesn't want to be a part of this house and transaction anymore, assigns its vendor's lien rights to the actual lender that gives the buyer the money once the deed of trust is signed. And that's how that works. They're two different liens. We talked about judicial earlier. We can not involve the courts, not file suit, and go and foreclose on a deed of trust. No problem. I've done it plenty of times. If I don't have a deed of trust to foreclose on, the vendor's lien is what I'm going to rely on. Got to file suit. It's a much different, more complicated process. How do we convey without a deed? What's a muniment of title? For an example of one. Yeah, probate. Probate and divorce decrees, the typical examples where I see muniment, okay? Muniment of title is basically going to convey without a deed to whatever the legal instrument says. If I'm probating a will only as a muniment of title, I don't have to open up an administration. I don't have to appoint an executor. I finish the probate, the judge signs the order as a muniment of title. Then if that will says dad's property was left to me, that's an automatic conveyance right there once the order is signed. That's what a muniment of title is. That's why a lot of good family lawyers include muniment language too, not just what I said earlier. Husband is divested of his right, title, and interest to the property. If I was a family lawyer, I'd do that and the muniment of title language. Because I talked about recording decrees earlier. That is muniment of title language, that's an automatic conveyance without a deed. Yeah, that's an order signed by a judge, right? So even if the decree doesn't have muniment language, I still want to record it if it has that divesting language. But I like the muniment because it's an automatic conveyance. All right, what did you say earlier? AWLT?
Oh, well,
What is it?
that's what.
Where'd you run into it? Why'd you bring it up?
Looking at court stuff.
Yeah. Anybody know what that is? An OLT? Or an OLT lien or an OLT of partition?
Oh, well.
A WLT?
Is that like a fractional ownership?
You're getting there, right? I mentioned OLT of partition because that's when you're dealing with fractions too. But OLT in essence is part of the split, most if not all the time in the divorce context. Remember I mentioned that family lawyers will put stuff in the decree that most of the time didn't happen. Well, it's a little bit easier sometimes when you create an OLT lien. All right, you're going to keep the house, but you're owed this much. That's the quintessential OLT of partition scenario. So you're going to keep the house, so you're going to deed your interest to him, but it comes with a price tag. Warranty deed with OLT of partition lien. So now you get 100% of the property, but you have an OLT lien that's pretty much just as good as a bank loan, right? Whatever the consideration is, whatever you were owed, that's the standard OLT scenario. Okay, a lot of family lawyers in town want to stay in their lane and they'll call me for these docs. They can get complicated. Hey, real estate guy, I have an OLT situation. Here's the decree. Can you draft my docs?
So is that pretty much the same thing as a lien against the property then?
Yeah. That OLT lien, when properly drafted, can act like a deed of trust. And guess what? You gave up your interest to him at a price. If he hadn't paid that price, you can call me as a trustee to go foreclose like I could any other lien.
What's the deed with vendors lien?
It's an OLT of partition lien that has a lot of the similar protections that a vendor's lien has. Yeah. I see where you're going with that because it's the owner and how do you protect that? Not the entire debt being paid. So it's in the spirit of a vendor's lien, but because of it more narrowly in the divorce, it's also a partition lien over a vendor's lien. Because you're not essentially selling your interest to your soon-to-be ex-spouse. You're divesting pursuant to a court order.
So what happens if I never collect or never get, like, because you said that essentially he owns your property, but I have there's an amount due to me, right? And so how does that happen? What happens in the future if I never do anything like that?
If you don't do anything,
Like I never exercise anything. What happens if he
And he has the free property.
yes, and his subsequent child gets the property?
it would still be subject to a lien that you haven't enforced. It doesn't die off because it's not here anymore. It's a valid lien.
And that's
That-
something you would locate.
Absolutely. Yeah, and that, yeah, you bring that type of transaction to title, we're gonna start asking about that OLT lien that you never enforced. Oh, whoa, owed this? Okay, well, we gotta start getting in the weeds and seeing who are the heirs, whether there's a probate or not, and who has the right to enforce that lien.
So I guess I'm a little confused. So would that mean like in her scenario, you would need to look for a release? Is there actually a release that defined, I mean,
Just like a release of lien.
is it defined as it called a release of lien and then it describes it as an OT document, or do you search for, or does the title say OT release or something like that?
I'll call it a release of OT lien. That way there's
I
no
mean, that's,
question.
yeah, so
I can call it a release of lien because it is a valid lien.
that's what it is.
But yeah, I'll call it a release of OT lien, and in the description, I'll talk about the divorce decree and where that's recorded. And I'll talk about where the warranty, that deed with OT and partition lien is recorded, and the deed of trust with OT and partition. Yeah. Most of us know affidavits of heirship. That's definitely a class that I've done over at Buffalo West, among other places. Joint with right of survivorship. This one's an interesting one. I love talking about it because now you're not only gonna read your deeds, but when you're a buyer and you're buying without your spouse, you're buying with a partner, whoever, that's not your spouse, you're gonna look at the grantee line now. How are you taking title? What's the general rule absent any other language? Do we know?
Joint tenant with rights of survivorship.
It's not the general. The general rule is tenants in common. Tim and I buy a house together. There's nothing in the deed or grantee line that says otherwise. We're tenants in common, not joint right of survivorship. What does that mean to Tim? I die tomorrow. My half doesn't go to Tim, a lot of people think. It goes to my estate and my heirs who don't like Tim. Good luck getting the other 50%. No, it happens all the time.
Yeah.
Read and ask and get the language that you want in the deeds. If there's joint tenant with right of survivorship, that's what that is. If there's language like that on the deed, Martin and Tim or Martin and Tim's entity, comma, as joint tenants with right of survivorship, and the same scenario happens, you don't need to do anything else. I pass tomorrow, Tim owns the property 100% for Tim's entity. That's how important language is in deeds. Yeah. I don't see people use that often enough. Anytime that I'm buying and it's not my spouse, I sure ask them to use that language, right? Because I don't know what Tim's getting into or what could potentially happen tomorrow. Nobody does. I don't want to mess with probate or his estate. Well, it's good to have that conversation with your partner beforehand, right? Hey, are we cool? We're doing this on our own. Something happens to one of us, you get it or I get it. That's right.
Martin, why are you having skydive today?
Yeah, just like the life insurance shows. What? You want me to up that life insurance? What are you doing? Where are you taking me? Yeah, there you go. Talked about muniment. Most of the time you see it will probated as muniment, or like I said, in a decree. Divorce decree may award house to one party or the other. The order itself acts to transfer the property. Decree has instructions often for the divested spouse to give a deed, but like I said, doesn't always happen. If no deed was executed, decree needs to be 40 days old for the title company to rely on it. That's happened 2 times, actually. Got a decree, I'm divorced. Yeah, you may be. But remember, I'm a risk taker. Why can't I rely on a decree that's not yet 40 days old?
That's going to be appealed.
Divorces happen at the trial court level. How many levels are there? 3. You can appeal it to the appellate circuit. You can appeal that decision to the Supreme Court. All right. If you're going to appeal, you better do it before 40 days, or there's a really good chance that the appellate circuit's not going to take your appeal. And I'm not taking that risk, right? Because someone can go and file on day 40. And then I'm in the lawsuit because I closed a transaction or allowed it to go through that was still in an appealable jurisdiction. Day 40, I closed on day 42 before. I like the facts. They weren't that angry with each other. And I knew that it wasn't going to be appealed, and it passed 40 days. OLT partition, talked a little bit about it, right? Court's not going to cut the house in half, but a lot of times we are dealing with fractions, if not 50-50. Partition is completed when an old deed is delivered to co-owner, conveying title while retaining a lien against the property. And that's what we're discussing. A valid lien in the spirit of a vendor's lien, old partition lien protected by a deed of trust. AOH, typically not a conveyance, but can someone tell me why we rely on affidavits of heirship, or when we do and why we can?
Well, when somebody dies without a will.
They can die with the will and we can use it too, but
Tells you who's entitled or who has potential interest.
potential interest, right? Because it's not a conveyance, so it's not who's entitled, but who has potential interest from the dead person who is on title. Right? It's a mechanism that allows us to be efficient if we don't need to take it to probate court. It's a non-judicial mechanism, right? Deceased was only married once, had kids with that same spouse. Those are the easiest facts to deal with. Whether they have a will or not, I can use this and prove up non-judicially who the heirs are and go from there. Close the transaction, no problem. Those are the easiest facts. It gets hairy when there's no will and when there's multiple marriages and kids outside of, or kids from each marriage or several marriages.
You've done several of those for me over the years.
We have, and the hard conversations to have are always surviving spouse that didn't have any kids with deceased, thinking that he or she could sell by herself, by himself. Not always, especially if you didn't leave a will and if you had kids from prior marriage. That one happens far too often. Hard one, but we navigate. I've got to take one to probate right now because of that. Oh, and talk to you about this one. Update your docs. Even if your lawyer should tell you, come back and see me, or if there's any circumstances changing, keep me in the loop. Pretty small price to pay to update your docs. These folks, albeit a good trust, created an out-of-state trust, but didn't update their docs as they started buying more property. And they bought property in Texas, and it was never properly conveyed to their trust. And guess what? Trust is built to avoid probate. I gotta take it to probate. The docs weren't updated. I tried my darnest to get this one through. I get creative, but I do it the right way. I'm like, I could get past the out-of-state trust issue, but I can't get past the not updating your docs and not properly deeding to your trust, your trustee. Yeah, watch out. That one can be very costly now because of a lack of updating docs. You buy a new property and you have a trust or an entity, call your lawyer's office. Do I need to do anything about this? What do you suggest? Chances are you might have to. Or update your will too.
So, the most recent probate one that you did just a couple months ago in Arlington, we had one of the heirs in prison. You remember that? How do you go about getting that signed? I didn't ask. I just know you got it done.
And I'm not so, y'all are like bright-eyed now, and I'm not so impressed by our abilities to do it just because we've been doing it a long time. We're kind of used to it now, whether it's, Huntsville or another institution. We just call the institution and say, this is what we have going on. Please get me on your calendar, because most of them have a notary in-house. I need to send some docs for inmate number so-and-so to sign. So I've had my people go 3 times if it's local because they think it's cool. Yeah, I'll go. Okay, come back, get what you need signed. But most of the time we call the facility and they will get us on the calendar and arrange. Yeah, we've done that often.
Has anybody been in a prison? It's not so cool.
Yeah.
I didn't go as a long-term guest,
Right.
but when I was in high school, I delivered a loaded soda truck. And one day they were short for delivery, so they made me go, didn't tell me where we were going. We went to the Michigan State Prison. I'm all of 120 pounds walking down the
That's the
aisle.
last slide, so I'm gonna go to the restroom real quick and then we'll close it.
Prisoners, both sides, staring at you. It wasn't a good feeling. So no, I was not there from the. this good stuff or what? Hey. Good stuff?
Yes, absolutely.
Martin giving you good stuff. He always does. This is always a good conversation when it comes. Giving you any ideas?
Yes.
Confusing you?
But we said we gonna go look at these at the courtroom.
Well, Lexington and Robin are in the deed stuff a lot because of what they do.
But I don't go down to the courthouse and, I mean, I did years and years ago, but everything's so automated and.
Yeah.
So that's, telling them, I said, we need to go down there. It'd be kind of fun to go down there and read, trade stories and, hey, look what I found.
I didn't know it was 5 years. I learned that, so I guess it takes 5 years to contest the deed now, he said, instead of 4. And I see adverse possession is 5 years. I'm not seeing it, so I gotta find that color.
So, not because I was ordered to, but the only one federal that I've been to is a federal courthouse downtown. Because sometimes, especially on hearing dates, you gotta bring your subjects in. Even that one was scary. I love being in courthouses, and that one's a very historical federal courthouse. But yeah, even the jail part of it is eerie.
Yeah. It wasn't a good feeling.
No. Yeah, the last slide is what we've already talked about, joint with right of survivorship, right? General rule, like I said, is co-owner's interest passes to that person's heirs, not the co-tenant. But they can agree in writing that it'll pass to one of us instead of our heirs and our estate. All right, and it's an immediate pass. That's the beauty of the joint right of survivorship. If our families are well situated and they don't need any interest in what we went into 50-50 or whatever, right? That's a great mechanism because it's an automatic conveyance to your co-owner. Super cool. All right, I got about 5, maybe 10 minutes. If we have any questions, thank you for your time as always. Appreciate it.
Thank you, Martin.
Yeah.
How about the deed restrictions?
Yeah.
An interesting one would be like for neighborhoods where it had to be an owner occupant, low
Yeah.
income deed restriction. Are those ever able to be lifted or are they in place until Gabriel's comfort blows?
What do you think?
I don't know. That's what I'm asking.
What, do you have an idea? Very smart guy.
It has to be in.
Yeah, there you go. How can deed restrictions be lifted? He mentioned some specific deed restrictions. Well, amended, but he's gonna sign it. I'm gonna look at the deed restrictions and see who the players are and who has the capacity to sign. Might be neighbors, not just the owners. So go find all the players and see if they're willing to sign, because if they're not, you're back in court. And then you fight it out in court until there's an order signed lifting said restrictions. That's how it's treated. What else you got?
I'll think of something.
No, I hear, but at least, most of you ask questions, and that's what I appreciate. I just want to hear myself talk.
The 5-year thing I see is adverse possession, but is there you said it was a contest period on the deed. I thought it was 4 years, you said, but the 5-year I see.
We were talking about the
possession.
quitclaim. Yeah, I mean, while people think of questions, I can pull it. It's on my estate's,
Oh, some just state.
Yeah.
Or conveyance.
it's on that PDF. I'm not recalling the code, but I can deal with it. And last time we did a legal update and case law update, the back part of that presentation had the new statutes with respect to the quitclaims.
Okay, so it should be.
It should be somewhere on the website, yeah, because that was
Okay.
last December. Yeah, last December.
This year, wasn't it?
I think, didn't we push that off to the first of the year though?
Or whatever it was.
Yeah.
It was in January.
I'll find it.
So it was in January post. Yeah, because the legislative session, they had like 5 or 6 special sessions.
Yeah.
And they weren't even done.
Yep.
That's why we pushed it out.
And was there a new baby in the picture somewhere?
Maybe.
Somewhere in that
January
area,
8th
from
of
what I
this year.
remember.
Oh, yeah. Number 2 arrived on the 8th.
They grow fast, don't they?
Yeah.
So, over the years, Martin's taken a lot of phone calls from me on probate deals. You know, to just get him on the phone with my sellers. Cause I don't even wanna pretend to understand all the ins and outs and what has to be done, whether it has to be probate or not. So I leave that to Martin. He just takes that call and has that discussion with him, so. It doesn't take him very long to determine what they gotta do once he asks a few questions. So, any other questions for Martin? Anything at all?
Good. All right, thanks.
Thank you, sir.
Appreciate you.
Thank you
Yeah,
for
so-
Mag Law and
Yeah. Yeah.
Select.
Thank you. Appreciate it. Thank you for the interaction too. Love the questions as always. Appreciate it. All right, gotta get to that. Said almost 1-year-old.
Yes, sir.
Thanks, y'all. We'll see you next time.
See you.
Yeah. Bye-bye.
See you.
Thank you, Mark.
Oh.